हेलो फ्रेंड्स, वेलकम है आप लोगों का मेरे शॉर्ट हैंड चैनल पे। सो बी रेडी फॉर द डिक्टेशन। लास्ट रेडी स्टार्ट when the principles of law as noted above are considered in the factual background, it is clear that the irrelevant and extraneous materials entered into the decision making process, thereby vitiating it. The order granting remission, which is impugned in the petitions, is clearly unsustainable and is set aside. However, it is open to respondent 1 to treat the petition as a pending one for the purpose of reconsideration. It shall be open to the governor to take note of materials placed before him by the functionaries of the state, and also to make such inquiries as considered necessary and relevant for the purpose of ascertaining the relevant factors. Otherwise, the writ petitions are allowed to the extent indicated above. In his concurring opinion stated, exercise of executive clemency is a matter of discretion and yet subject to certain standards. It is not a matter of privilege. It is a matter of performance of official duty. It is vested in the 10/2004 7 SCC 634 Criminal Appeal number 1003 of 2017 Pyarelal versus State of Haryana President or the Governor, as the case may be, not for the benefit of the convict only but for the welfare of the people who may insist on the performance of the duty. This discretion therefore has to be exercised on public considerations alone. The President and the Governor are the sole judges of the sufficiency of facts and of the appropriateness of granting the pardons and reprieves. However, this power is an enumerated power in the Constitution, and its limitations, if any, must be found in the Constitution itself. Therefore, the principle of exclusive cognizance would not apply when and if the decision impugned is in derogation of a constitutional provision. This is the basic working test to be applied while granting pardons, reprieves, remissions, and commutations. Granting of pardon is in no sense an overturning of a judgment of conviction, but rather it is an executive action that mitigates or sets aside the punishment for a crime. It eliminates the effect of conviction without addressing the defendant's guilt or innocence. The controlling factor in determining whether the exercise of prerogative power is subject to judicial review is not its source but its subject matter. It can no longer be said that prerogative power is ipso facto immune from judicial review. An undue exercise of this power is to be deplored. Considerations of religion, caste, or political loyalty are irrelevant and fraught with discrimination. These are prohibited grounds. The rule of law is the basic for evaluation of all decisions. The supreme quality of the rule of law is fairness and legal certainty. The principle of legality occupies a central plan in the rule of law. Every prerogative has to be subject to the rule of law. That rule cannot be compromised on the grounds of political expediency to go by such considerations. Stop. Thanks.